Good morning, and thank you for joining Mayor Brown's Global Financial Markets teleconference series. I am delighted to introduce today's call entitled An Introduction to Islamic Finance and Key Structures. My name is Michelle Jewett, and I'm a tax transactions and consulting partner in Mayor Brown's New York office. First, a couple of housekeeping items. As regular listeners will know, this call is being recorded. We will be emailing an audio link to all participants should you wish to listen to the teleconference again or forward it to your colleagues. In addition, the recording will be available as a podcast on your preferred podcast platform. Since we will not have a Q&A session, please send your questions regarding today's topic by email to gfm@mayorbrown.com, and we will respond promptly. This is the same email address on your invitation email. Joining us today is Mayor Brown partner Barry Cosgrave. Barry is a partner in Mayor Brown's restructuring practice in London and Dubai. He concentrates his practice on distressed debt and restructuring, debt capital markets, structured finance, and Islamic finance. He also advises on Middle East regulatory matters and is an advisor to leading international banks, hedge funds, investment and asset managers, and insurance companies on the full range of banking, funds, securities, broker-dealer, and insurance regulation. With that brief introduction, let's begin today's discussion. Barry, I'll pass it over to you.
Thank you, Michelle. Good morning, everybody. Today's podcast will focus on Islamic finance and an introduction to Islamic finance and some of the two of the key financing structures that we use within Islamic finance. Broadly, the content of the session will be an introduction to Sharia and some key Sharia principles and prohibitions, the role of Sharia scholars and Sharia boards in Islamic finance. We'll touch on some case law that has addressed issues in Islamic finance. We'll talk about two key Islamic finance structures and techniques, and then we'll give a brief overview of some structuring issues that relate to Islamic finance. So to kick off on the background to Islamic finance, Islamic law is based on a body of law known as Sharia. Sharia is derived from a number of sources, including the Quran, which is the primary source, the sayings of the Prophet Muhammad, or the Hadith, and his teachings, the Sunnah. It is not a codified system of law like one might expect from various United States or from under English law, so there is no book of statute that deals with Islamic finance. Instead, it is subject to interpretation by individual Sharia scholars and boards of Sharia scholars as to how to apply the various sayings that go into the body of Islamic law and how to apply those to financing structures. Those structures are reviewed by the scholars and subject to the issuance of a fatwa, which is a little bit like a cross between a letter from a rating agency and a legal opinion from a law firm, in that it addresses those matters as interpreted by that scholar. It's very important to know within Islamic finance and within Sharia, there are differences of opinion. There are two main branches within Islam, Sunnism and Shiism. The majority of Muslims are Sunnis, and within Sunnism, there are different schools of thought. Some of the main schools of thought are the Hanafi, Hanbali, Shafi'i, and Maliki. And there is extensive Islamic jurisprudence that has been developed over the centuries by different schools of Islamic scholarly thought. All schools of thought agree, however, on certain fundamental Sharia principles that are applied to all Islamic finance techniques. There are, however, differences of opinion around specific structures and the implementation of those structures. And as a result, it would be fair to say that no two Sharia compliant transactions are the same, and each one has to be assessed on its own merits and its own value. However, as I mentioned, there are certain fundamental principles that apply to all Islamic finance structures and all Sharia transactions. The charging of interest or riba for the use of money is prohibited. As a result, a conventional lending transaction is not prohibited. That's not to say that the lending of money is not allowed under Islamic finance. It is, but it has to be at a zero interest base. As a result, therefore, and we will come on to this later, specific structures have to be included that allow for a profit to be generated by means of investment. Sharia also prohibits uncertainty in contracts, which means that, for example, gambling is an absolute prohibition. It also means that an investment in a business that may have a casino attached to it or similar would be prohibited. The application of uncertainty, or the uncertainty principle in contracts, is one that's always open to interpretation. So, for example, derivatives, conventional derivatives to be used in Islamic finance have to be specifically related to managing risk and not to be speculative. As a result of that, if you want to enter into some kind of Islamic risk management, it has to be in relation to a real risk that's being looked after. So, for example, if you have an airline that is subject to fluctuations in the price of fuel oil, it is allowed to hedge itself or to manage its risk of the fluctuations in the price of fuel oil, but it could not, for example, take some speculative positions on how it might anticipate the price of fuel oil performing in the future. There are also certain commodities that can't be dealt with in Islamic finance. What we'll discover when we talk about the Murabaha transactions later on is that the trading in base metals is permitted, but if you wanted to trade in, for example, gold or silver, that would be seen as the equivalent of money, and therefore you would be paying money to buy money, which is not permitted under Islamic finance. We talked a little bit about Sharia scholars, and it really is the Sharia scholars that drive the body of Islamic law that we call Sharia law or Islamic law. There are certain specific scholars in the market, some of whom have established Sharia advisory companies themselves, such as Dar al-Sharia or Amani Advisors. Their role within a transaction is to really go from the beginning to the end to make sure that along the route, everything that we do complies with Sharia as interpreted by that scholar. So in the process of a transaction, typically how we start the transaction is once we have decided on the commercial terms between the parties, we will then prepare a Sharia structure memo, which will have typically a structure diagram with some accompanying commentary that can then be submitted to the Islamic scholar for its review. The scholar will look over the structure and will issue a preliminary fatwa, which essentially says it has no issues with the structure itself, and subject to the documentation being prepared, they are happy for us to proceed with the transaction. At that point, we then begin the drafting of the transaction documents, which will then be negotiated between the commercial parties, legal advisors, rating agencies, and whichever other stakeholders may be involved, until we've reached the point at which we have broad commercial agreement on the terms. At this point, those long-form documents then get submitted to the Sharia scholars, who will review in detail, effectively line by line, and provide comments on those documents from a Sharia perspective. And once we have an agreement with the Sharia scholars, and there's always a bit of negotiation and some structuring as to how to address their issues in a way that both complies with Sharia and also meets the commercial imperatives of the transaction, we can then finalize the documents and move through to signing. One of the key things that's issued by a scholar at signing, along with legal opinions from various law firms, a rating agency letter if required, is the final form fatwa, which will sign off on the Sharia compliance of the documents as interpreted by that scholar. As I mentioned earlier, there are differences of opinion, and depending on the transaction that we undertake, if we're doing a public markets transaction, one of the risk factors that we will always include as part of a disclosure document is a risk factor that explains that there are differences of opinion within Islamic law, and therefore any investor, to the extent that they wish to comply with Sharia, should not rely on the fatwa that's been issued in respect to the transaction, but rather should consult with their own Sharia advisor in order to ensure that what they're investing in complies with their religious beliefs as interpreted by the scholar most applicable to them. That's not to say that we hide behind the Sharia structure, and clearly, having engaged with a Sharia scholar, you would anticipate the transaction to be compliant, but there have been instances where challenges have been raised as to the validity of a Sharia-compliant contract, which we'll come on to in a moment. It is very important on any Sharia-compliant transaction to work closely with the scholars, and very important, therefore, as advisors on a transaction and commercial principles, to have a good working relationship with the scholars. On the whole, scholars understand the need to be commercially aware and commercially sensitive, and they do a very good job on the whole of balancing what a commercial party wants to achieve with what is needed for the purposes of Sharia compliance. It is an iterative process. There is back and forth with the scholars, and there is a need to accommodate their needs and their views alongside the commercial realities. But on the whole, scholars equally understand that there is, to a certain extent, it's fitting a square peg into a round hole. And so we do need to, when we're doing complex cross-border structured finance transactions, there needs to be an ongoing dialogue and an explanation and an understanding between both sides as to in order to achieve the goal that's intended. So I talked a little bit about the fact that there is some case law on Islamic finance. Most cases in Islamic finance, or to the extent that there is case law available, have been heard under English law. That's partly to do with the fact that, whenever doing a cross-border financing transaction, it tends to be a decision as to whether you use New York law or English law. For Islamic finance deals, predominantly they have been governed by English law, so your contracts will be English law governed, with your dispute resolution to be decided within the English courts. Equally, arbitration can be used if that's a decision made by the parties. There are certain cases that have been decided, two of which that are quite important, is the Shamil Bank of Bahrain and Beximco Pharmaceuticals, and also the Islamic Investment Company of the Gulf and Symphony Gems. Those two cases were heard in the English courts. Both were challenges as to how a document that was supposed to be governed by Sharia or supposed to comply with Sharia would be interpreted by the English courts. The details of the case are not important for the purposes of today's session. What's the most important takeaway from that is that the English court said that they would review those documents in accordance with English contract law principles and would not have regard to the Sharia compliance or not of those documents, which were a matter of conscience for the various parties involved. There was a case, the Investment Dar and Blom Developments Bank case in 2009, where Blom Bank brought a case for summary judgment against the Investment Dar, or TID. A summary judgment, for those that don't know, is a process in the UK courts. It's a fast-track judgment that can be issued by the courts as to the resolution of a particular dispute. That's important because in defence against the application for summary judgment made by Blom Bank, TID launched a defence that the contracts to which they had signed up were not in fact Sharia compliant. TID, being a Sharia compliant investment company, was only permitted to sign up to Sharia compliant contracts, and therefore, on the basis that these contracts were not in fact Sharia compliant, they launched an ultra vires defence to say that they did not have the capacity and authority to enter into those contracts. It's very important to understand that this was a case around summary judgment, and the judge in this case said that he believed the dispute was not suitable for summary judgment, and if it were to be litigated, should go to full trial. He alluded to the fact in that judgment that there could be some grounds to consider on the basis of expert evidence whether or not the contracts were in fact Sharia compliant and whether an ultra vires defence would work. But it's very important to remember that he did not actually pass any judgment on those matters, but rather said that the case was not suitable for summary judgment. More recently, a case involving Dana Gas and a sukuk that it had issued similarly launched some ultra vires defences. And whilst those ultra vires defences were not considered in the English courts, what is important is that the English courts issued their judgment on that case in accordance with English contract law principles and some very specific narrow interpretation of some case law related to that. There is some case law, or at least one case in the United States, somewhat surprisingly, coming out of the Louisiana District Court, This was in relation to the East Cameron sukuk, which was a sukuk issued by an SPV and related to a true sale securitization of certain drilling rights in the Gulf of Mexico. This was a bankruptcy case that was heard out in the Louisiana District Court, and the key takeaway from that case is that the court upheld the true sale analysis that was undertaken in line with those documents, and did not it applied U.S. law principles or Louisiana state contract principles, and did not have regard to Sharia compliance or not of the documentation. So as I mentioned, what I'd like to talk about now is two of the key structures that are used in Islamic finance and the techniques that are employed. One of the key underpinning principles of Islamic finance is you cannot lend money and charge interest, as we discussed earlier, but it is possible to trade goods and to earn a profit on those goods. Therefore, as a result, it's relatively easy to put together a Sharia compliant structure for a company that has a large bank of assets. So, for example, if you have a company that has a large real estate portfolio, you can use an ijara transaction, a sale and leaseback transaction, which we'll talk about in a moment. However, the majority of companies do not sit on a large inventory of assets that they can use to buy and sell. And therefore, what we use is a technique called a commodity murabaha. An understanding of a murabaha would lead to an understanding of approximately 60% of the Islamic finance market. It's an extremely well-used tool. It's used for bank financing, it's used in derivatives, and it's also used to help create Sharia-compliant feeder structures to invest in conventional funds in the US and Europe. At its basic, a murabaha is pretty well suited to corporate financing. So any business that's looking to get either a revolving credit facility or a term facility can use a murabaha structure. The way that a murabaha works, and it's hard to explain without the use of a diagram, and we will circulate some slides to go alongside this recording. But essentially what a murabaha does is it involves the buying and selling of commodities, where the commodities are sold for spot delivery but on deferred payment terms. And having a deferred payment structure in place enables you to charge a profit on the price of those goods. So essentially, you have your bank that's looking to provide finance to company X. Rather than the bank simply lending, let's call it $1 million to company X, instead the bank will go and engage with two commodity brokers. And instead of, as I say, lending the money to company X, the bank will buy $1 million worth of, for example, copper from a broker, which it will then sell to company X on spot delivery terms, but on a deferred payment basis. So the bank transfers $1 million worth of copper to company X, and company X will then engage with a second broker and immediately on-sell those commodities for $1 million. The net position, therefore, is the bank has sold commodities worth $1 million to company X. Company X has $1 million in cash in its bank account as it would want to. It then agrees to pay the bank on a deferred payment basis for those commodities. And because the payment is going to be deferred, the bank is entitled to charge a profit on those commodities, which can either be a fixed rate or a variable rate. So effectively, it's a markup to compensate you for the delayed payment that has been facilitated. The commodity murabaha is a structure that underpins, as I mentioned, bank financing, derivatives, and many other financing techniques within Islamic finance. It probably accounts for approximately 60% of the market. It's extremely flexible, and whilst it's not accepted by every scholar in the market, it is also understood by most scholars to be the most practical way and pragmatic way to implement a Sharia-compliant investment structure. It's very important that we use commodity brokers, but it's also very important to distinguish that a commodity murabaha is not engaging in commodities trading or commodities brokering. It's very simply a vehicle to allow money to be transferred between parties in a manner that complies with Sharia. The brokers that we use tend to operate on the London Metal Exchange, which is the central location for trading in base metals globally. It's important that we use base metals because, as I mentioned earlier, gold, silver, and platinum are seen as cash equivalents. Therefore, you cannot use gold to be your commodity in a commodity murabaha. Instead, what we use are base metals such as copper, aluminium, etc. And the reason we use the London Metal Exchange is because there are certain requirements. For example, grade A copper has to have a certain purity as required by the London Metal Exchange. That helps greatly with the scholars because it provides you with that certainty as to what is being bought and what is being sold. The commodity brokers need to be separate entities because otherwise it can look like what Sharia scholars describe as disguised lending if you simply buy from a single broker and sell straight back to that broker. Therefore, we have two separate legal entities acting as the brokers on that transaction. The other structure that I'd like to talk about today is an ijara structure, which is essentially a sale and leaseback structure. This is very commonly used, and its origins really come from the aviation market, where sale and leaseback of aircraft is very common. It can also be used for companies that have a lot of real estate and any other hard assets. It's also been used in slightly more esoteric assets, such as source code for intellectual property for a computer program, or for airtime vouchers for a telecoms company out of Southeast Asia. It's a much more straightforward structure to understand compared with a commodity murabaha. Essentially, you have a bank is looking to provide finance to company X, or let's call it company Y this time. Company Y has a large tract of land that is available for development or otherwise. Rather than simply lend the $1 million to company Y, the bank in this case will buy the beneficial title or equitable title to that land from company Y, and then lease that back to company Y over a period of time. As with any lease, company Y is required to pay rent, so it receives an upfront payment for the purchase price of the land, so our $1 million, and then it will be required to pay rental on a monthly, quarterly, semi-annual or annual basis, depending on what the commercial terms are, and the rent that it pays will either be a fixed percentage amount of the purchase price or a variable amount linked to, for instance, a variable rate, IBOR in the old days, and whichever risk-free rate we end up with in the future. Those lease payments are made on a monthly or quarterly basis, depending on how the commercial terms of the transaction may require. And at the end of the life of the financing, at the end of the lease term, which may be, let's call it 5 years, typically the company will have the right, structured a little bit like a call option, but under an undertaking. The company will have an undertaking from the bank that commits the company to exercise its rights to buy back that land at maturity. There is then a commensurate obligation on the company under a similar undertaking to buy that land back from the bank at a price, typically whatever the principal amount of the financing to be provided. So in our example, the company would have an obligation to buy back the land, the beneficial title in the land, from the bank at a price of $1 million. And that gives you a bullet repayment profile. That can equally be used to accommodate amortization or balloon repayment profiles on your financing as may be required. And so finally, I'd like to come on to some of the issues around structuring Islamic finance transactions. It is, as with any financing, cross-border financing structure, you need to have regard to the conventional issues that will apply. Legal validity is an incredibly important issue, of course. It's not simply good enough to have something that complies with Sharia. It has to be valid from a legal perspective. And from that position, you have to consider whatever the governing law of the financing is, so for example, English law, combined with local law issues that may relate to security and enforceability of security. You need to obviously ensure that you have Sharia compliance. You need to be very cognizant of the tax treatment. This is particularly important for cross-border transactions and how it may affect both parties depending on where their jurisdiction of incorporation is. Accounting treatment has to be considered, as well as regulatory issues, and that's particularly live at the moment in the UAE, where certain regulations have been brought in to govern murabaha transactions. You then need to. It is also possible to structure transactions where you have both a conventional facility and a Sharia compliant facility. and intercreditor issues become particularly important there. One of the issues that can tend to come up is, for example, late payment interest and late payment interest that may be imposed by a local insolvency court. Whilst the conventional banks will be able to receive that late payment interest, it's not something that can be received by an Islamic bank. And so the Islamic bank will want to waive its rights to receive any interest that may be imposed by a court, but that has to be balanced with the fact that the conventional bank will not want to sacrifice that right. There's a number of other issues that need to be considered. Typically, Islamic finance transactions involve the establishment of SPVs in offshore jurisdictions. They are there to facilitate, for example, with an Ijara transaction, the SPV will be the entity that buys the beneficial title to the relevant asset. We need to consider where that corporate vehicle is going to be established, what the cross-border tax treatment may be, and also the enforceability potentially within that jurisdiction of the Sharia-compliant transactions. As I mentioned today, the intention of our discussion was to give a broad overview. It would not be possible in this sort of space of time to give you a full deep dive on all of these structures and techniques. There are multiple other structures that are used for Islamic finance. However, Murabaha and Ijara are the two most prominent and are the ones that are seen in probably 80 to 90% of transactions in the market today. So this brings our call to an end. Thank you for tuning in to our call today. A few brief reminders. You will receive an email with a link to the recording of today's call, together with some slides that accompany it, and it will also be available as a podcast. Lastly, if you have any questions related to today's content, please email them to gfm@mayorbrown.com. Thank you again. You may all now disconnect.